The information provided on this show does not, and is not intended to, constitute legal advice. Instead, all information on this show is for general informational purposes only. The information provided is not a substitute for legal advice, and we recommend viewers consult an attorney for specific legal matters.
Good morning. Welcome back to Condo Craze and HOAs. We are live on our YouTube channel. I'm Karen Curtis, and I join Counselor Eric Glazer.
Good morning.
We have been live together on the radio and on YouTube for over 15 years doing this condos and HOA show, and there's a lot to talk about because new laws are really starting to impact people. But we're here again today to learn more about anything that impacts your community association. If you live in one, half the state does, you probably have questions, or if you're on the board. Eric is board certified in community association law. He has a law firm in Fort Lauderdale and in Orlando, and we'd love to get the phone lines going early. Also the chat box on YouTube. No matter where you're in the state, the country, the world, it's toll-free, 717-GLAZER-8 with a Z. That's 717-452-9378. And you can also, again, visit us on the Condo Craze and HOA's website.
Hey, good morning, everybody. And of course, if you're a fan of the show, don't forget to subscribe to two things. Number one, the Condo Craze and HOA's channel on YouTube. You can watch the show live, ask questions, or if you miss a live show, watch it at your convenience. We really got amazing library. And of course, join our email list at condocrazeandhoas.com. By joining each week, you can get announcements about the show, our blog, our free seminars. Lots of them are coming up. Our newsletters, updates on the law, and a lot more. So make sure you join. We got about 11,000 on that list. And Karen, where can they find us otherwise?
Of course, you can find us on Facebook, TikTok, Apple, Spotify, and soon Twitter.
And we do a blog every Monday morning at hoa-condoblog.com. Again, hoa-condoblog.com. Tomorrow's topics will kind of go over what we went over today. The DBPR has lots of new powers when it comes to condos, but what about HOAs? You know, a lot of people have been calling me, does this apply to HOAs? I'm afraid to give them the answer. For those of you who were kind of waking up this morning and turning on your TV for the first time, you know, you got to talk about news sometimes on the show. Like I say, you turn the TV on, and what do you see? You see that Hezbollah launched a rocket attack into northern Israel that, it's so terrible to say, that killed 12 little kids playing soccer. That's what they aimed for, 12 little school children playing soccer. I mean, an unbelievable mess in northern Israel and the Golan Heights. So I think what I want to do for those little kids is have a few moments of silence for them, okay? Thank you, everybody. I appreciate that. Amazing. And the response that's coming is going to be amazing.
Oh.
And yeah, things have just escalated to a completely new level as of what happened this morning, unfortunately. Okay, back to what we do every day. Karen, you sent me an interesting article.
I did.
Let's put it up there if we can. Let's see what we can do.
We may have a special session.
We may have a special session. So there's a couple of things going on.
Yeah, there's a lot because the governor's hearing from people that are complaining that these new laws are just destroying condos.
Right. So apparently Governor DeSantis was in Aventura yesterday, and he made a comment, something to the effect like, well, this is the bill they put in front of me. This is the bill that I signed. So if they want it changed, okay, let me know. Let's call a special session, and if you want me to sign a different bill, put together a different bill, and okay, we'll talk about it.
But he can call a special session.
He's going to call a special. Well, he's saying, tell me to call one.
Yeah, I see. Okay.
I don't think it's going to happen.
Oh.
I really don't think it's going to happen because there are representatives who simply worked too hard on this. And what are we going to do? We're going to let a situation happen again where people don't have to pay reserves? Really? Is that what we're going to go back to
Well, he's
after
talking about
all of this?
unintended consequences, which are the article that I sent you.
You know what the unintended consequences happened? You know when they happened? They happened when you allowed developers to create fake budgets and tell people that you don't have to put money away for a rainy day. That's when unintended consequences were created, unfortunately. So I'm sorry, now you have to fix it. The line that we say on the show repeatedly is, now the bills come due.
But now everyone's trying to move out of these buildings that are 30 years old.
Now we go to the next story that Karen sent to me this morning. Look at this. Miami homeowners race to sell condos before 2025.
That's when the bill's due.
That's when the bill is due.
They want to get out.
Just look at this. Miami's housing market is currently inundated with aging condos driven by owners eager to sell before new stringent regulations take effect later this year. According to ISG World's recent report, nearly 90% of active listings in Miami are condos that are over 30 years old, contracting sharply with just 3% under a decade old. Well, why? Because those condos that are 30 years old are approaching their first inspection, right? And they may fail, and they have Zippo in reserves.
That's right.
Right. So that was allowed to happen, right? So now you're going to create a condo market that is going to tank.
But the legislature is moot because Miami-Dade has its own laws.
Has its own laws too. That's
regarding
exactly
this.
Right.
So
right. Miami-Dade
even if they have a
it.
special session, it's not going to fix anything.
But what they don't have, you're 100% right. Miami-Dade has their own laws. They're going to have to go through their inspection, regardless of what this new law said. But what the new law did do is say, okay, now you have to fund reserves.
Right.
Going forward.
Okay.
Full funding of
so
reserves.
that's not on Miami-Dade's level. That's
Correct.
only in the state
that's
law.
On the state
that's
level.
where the
Very
major.
good.
So I
this
guess
could always confusion on
so
that.
if the lawmakers do have a special session, they can do something about the 2025 bill is due.
Right. Correct.
That's what needs to happen.
But look at what the next paragraph says. The region encompassing Miami-Dade, Broward, and Palm Beach counties totals 20,293 active listings, predominantly comprised of condos aged 3 decades or more. I mean, just think about that. How are you going to sell your unit?
Well, here, I know.
Unless you're basically giving it away.
The billionaires are buying up Miami-Dade.
Yeah.
You've got Ken Griffin, you've got Bezos. So the millionaires are going to Fort Lauderdale.
Really?
So what the billionaires could buy up the whole building
and
maybe raise it and build a new one.
And where are regular mom and pop going?
They're leaving.
They're leaving. But you know what? You say leaving, right? But this law that requires inspections and this law that requires reserves, that applies to everywhere in the state. So it's not like you can go inland and get away from it. If your building is 30 years or more, sorry. It's going to follow you everywhere, this law. So the best thing to do may be to go to new housing that's starting fresh from the beginning, right? That doesn't have any repairs to be made, that has the 30-year inspection way off in the future. That's going to start reserving from the beginning, but you're probably going to pay more for the purchase. Right?
Well, first you got to sell you got to unload.
Right, so you got to give away what you have. We're in a tough spot, but
say, look, my constituents cannot pay.
I understand that. Maybe, though, they should have not waived reserves for 30, 40 years in a row. Should we, so I'm asking you this, should we put them back in their condos, right? And say it's all right, okay, no problem. After
and
all,
one
we just
falls
went
down.
All right, no, and you don't have to pay reserves, no problem. We were wrong about the whole thing. You can go back waiving, no problem. Is that what we should do?
No, but maybe, I don't know.
It's pretty hard. It's pretty hard to strike a balance.
It's not a balloon mortgage type situation.
So what do you? So look, a lot of associations are getting through this by borrowing money,
right?
And that's what they're going to have to do. You know who's going to make a lot of money out of all this? The banks, which they always do.
Right.
So associations can always borrow money here, but the truth is, once they borrow long term, like a 20-year loan or something like that, that loan will be on the books.
It's the albatross.
Forever.
And anyone moving in is going to have to pay for it.
Exactly. And the truth is, in about year 10, they're going to need something else. So they're going to go back to the bank and say, hey, can we refinance this and get another line of credit? and in year 15 they're going to need something else, and
They're always underwater.
that loan, they'll never get to a spot ever where that loan is completely paid off and there's not one that's not on the books. That's this attorney's opinion. Okay? That's how it's going to be.
So you're saying no special session.
No, I'm not in favor of it. I got to tell you, I'm not
But do you
in
think there
favor.
will be one?
No, I don't think there
Okay.
will. I'm going with no at the moment
Okay.
because remember what the vote was.
Oh, it's not unanimous.
The vote was 110 to 0.
Yeah.
So
Why would they go back and fix it?
Right. I mean, I'm thinking that they're
They look like they messed up.
Yeah, and just remember something. Condos are big in a few counties. Obviously, Dade, Broward, Palm Beach. Maybe Jacksonville up there has a lot of condo. The rest of the state, mostly HOAs.
Right.
So you're talking about 3/4 of the members of the legislature. It's not really a problem to them because it's mostly HOAs. So I don't think this is going to be called back into session. That's my opinion, but time will tell. Okay? All right, let's get back to the topic of the day. Thanks for bringing that to
You're
everybody's
welcome.
attention. All right, there have been lots of complaints over the years that when condo owners bring their complaints to the DBPR and expect some help, the only thing they get in return, and I've seen so many of them, is a letter that says, hey, the DBPR has no jurisdiction. We can't help you with this subject matter. Sorry. And I actually watched a legislative hearing a few months ago in Tallahassee, and I'll tell you that there was a lot of people testifying to that effect in front of this committee, and the legislators who were hosting the committee were absolutely shocked. They really, truly had no idea that this was actually going on, and they want to do something about it. In response, the legislature passed a law this year giving the DBPR jurisdiction over many, many more subject matters. And this bill became effective July 1st. And Karen, we got to do this together.
Yep.
Because there are so many new subject matters.
Unless you think the DBPR can't handle these new things, they've
guess
been
what?
overfunded forever.
Well, now they get to keep their money.
That's right.
Yes, they're getting to keep that money.
And they can hire more
Their
people.
budget was just basically doubled. The amount of
there
money
you
they
go.
received is going to be doubled.
Okay.
So here we go. If you're playing along at home, the statute that is in effect here is 718.501, and it has to do with authority, responsibility, and duties of division of Florida condominiums, timeshares, and mobile homes. All right, Karen, start us off.
Okay, so after turnover has occurred, the division has jurisdiction to investigate complaints related only to procedural aspects and records relating to financial issues, including annual financial reporting.
Okay, that's good. So I'm
Okay.
just going to stop you there for a second. So I once filed a complaint and they told me they had no jurisdiction over financial issues. So now you can make a complaint that your association is doing something incorrect with financial issues and
that's
financial reporting.
HOAs and condos?
This is for condos, remember.
Oh, but the hammocks. Okay.
This is the HOA had the DBPR had nothing to do
Nothing,
with it. Nothing
yeah.
to do. That was all police.
Okay.
That was all
Well,
detectives.
yeah, DBPR doesn't help the HOAs.
Correct. So okay, so now they can investigate financial matters.
That seems like that should have been going on a long
think?
time ago. My
Right.
God, help me. Assessments for common expenses, fines, and commingling of reserve and operating funds.
Okay, they used to tell you if you bring a complaint having to do with payments of money. We don't talk about payments of monies. So if you have a question about your budget, payment of monies, who's paying, who's not paying, sorry, we can't help you. Okay, so even that they threw you away for. Now they get to hear it.
And use of debit cards for unintended purposes.
Excuse me, my manager is using our debit card for blackjack at the
Hard Rock.
At the Hard Rock. Can you do something about this? I'm sorry, we don't have jurisdiction. It's crazy, right? You would
Yes.
think you'd go to the DBPR and that's something they would jump on in a second.
Right.
Nope, they'd throw you away.
Right.
Okay?
That's
Oh
a
my-
true story, right?
Yeah, that is a true story. That actually happened. Correct. Exactly. All right, let's keep going. New things that they can investigate. The annual operating budget and the allocation of reserve funds. Financial records. Okay, let's stop the allocation of reserve funds. You tell the DBPR, hey, my condo just used reserve funds for something that they shouldn't have used reserve funds for. They can investigate that now. Financial records and any other record necessary to determine the revenues and expenses of the association. Check ledgers, checks, a lot of power.
Yeah, so, and elections including election and voting requirements, recall of board members, electronic voting, which is really interesting, elections that occur during an emergency, and financial issues, and just elections in general.
So isn't that great? I mean, think of...
I can't believe this weren't already covered by the DBPR.
Listen, you have no idea. Everybody got the letter back that said, sorry, we don't have jurisdiction, okay? Now, basically everything.
It was like the Wild West.
Yes, correct. And this is what, you know the frustration that people were having? It was driving people nuts. I know I'm talking to that camera.
Yeah.
And I know there's so many people that are sitting at home
yes.
saying, yeah, right on, Eric, absolutely, right on, Karen.
How quickly does the DBPR get on top of this stuff?
They will. You know what? I'm gonna stick up for them for one thing.
Okay, good.
What do you want from them if by statute their hands were tied?
Right.
What do you want? You know, there's by statute their hands were tied.
Right.
Guys, now you got a budget that's basically doubled from my understanding. You got power to investigate all these things. Go at it. Show everybody that you're there for them. I think it's pretty important to do. The procedural aspects of meetings, including unit order meetings, quorums, voting requirements, proxies, Board of Administrations, budget meetings. You go and complain to the DBPR. There wasn't a quorum at the meeting. There wasn't a quorum of the directors. Yet the board did this. There wasn't a quorum of unit owners at the meeting, yet they amended the declaration, whatever it may be. They're going to be able to investigate all these things. This stuff happens every single day. So, really good things.
Also, the disclosure of conflicts of interest.
Yep.
The removal of a board director. Actually, but the board can do that themselves.
The board can't remove a director. The board can remove an officer.
Excuse me, or officer, and any written inquiries by unit owners to the association.
Yeah, unit owners have the right under the statute to send a unit owner inquiry to the association. Question, and the law says they have to answer within 30 days. They can get 60 days if they ask their attorney to answer the question. If that's not responded, their penalty is that if this issue goes to court and they win, they don't get fees. But now, in addition to that, DBPR can investigate. Why aren't you answering the unit owners, right?
I love it.
So there's pretty much power to investigate almost anything now, I think. Members of a condo, you should pretty much be happy about that. And let's hope none of you get letters any longer about the DBPR not having jurisdiction. If you do, I want to see the damn letter. Okay, I really do, if you get one of those going forward. But here's what may be an even more important change to the law, and I really think this is a biggie. The division shall refer to local law enforcement authorities any person whom the division believes has engaged in fraud, theft, embezzlement, or other criminal activity, or when the division has cause to believe that fraud, theft, embezzlement, and other criminal activity has occurred.
Okay.
Think about that one. You know how many times complaints of a criminal nature were brought to the DBPR? Sorry, we don't have jurisdiction. I mean, the frustration that unit owners have suffered, you know.
I mean, you as a unit owner can go ahead and send this to the DBPR. Just don't post that your directors are thieves.
Yeah, don't say it exactly. Don't accuse anybody in a meeting. You're a thief. Don't post
criminal.
it. Unless that person is, you know, arrested, convicted.
There you go.
Do what the hell you want. You
know? So now, the DBPR must refer lots of cases to law enforcement.
Yeah.
Okay, where they believe financial wrongdoing has occurred, but you do think it's going to result in the prosecution of more cases, or because the police are kind of like?
I actually think it will.
Really?
This is different. A lot of people walk into police stations and say, my board is stealing, and the cops must look at them and say, we got a crazy person. They're not going to take it seriously. You know, okay, yeah, it's a civil matter, right?
Right.
People hear it's a civil matter when they walk into a police station. Yeah, and they turn it away, but the cops will turn it away, unless it's served up to them on a civil platter.
Well, with the teeth of the DBPR now, that's going to give them some...
If it comes from the government and a government agency, saying, they would call, for instance, the Dade State Attorney's Office or the Broward State Attorney's
Right.
Office. They'll put together a package and send it over there.
Instead of a little person
Instead
coming
of a
in.
little
Yeah.
person walking in, right. So if it's coming from the DBPR who did an investigation and say, yeah, we believe fraud and theft happened here, yeah, I think they're going to investigate it. And I do think there's going to be more arrests. And time will tell. We'll see what happens. But I'd like to know what our listeners and viewers think of that. Give us a call here in the studio, 717-GLAZER-8. Again, 717-GLAZER-8, 717-452-9378, or drop us a question or a comment in the chat box on YouTube. We'll be back right after this.
There are very large management companies, and there are very small management companies, and I think Affinity sits somewhere in the middle of that, where they are big enough to provide you with all of the back of the house services, the accounting, the infrastructure, the support systems, but small enough to be high touch.
We believe at Affinity that we do the 9 to 5 so that you don't have to do that.
Oh no, an unexpected leak. Jay, you know that's no way to solve a roof problem. Call Best Roofing. We solve roof problems.
We are DMI Paving and Seal Coating, Florida's parking lot experts. We specialize in asphalt paving and repair, including pothole repair, seal coating using JC7 or polytar, concrete curbs, ramps, and walkways, and striping and pavement marking, as well as ADA compliance. We service commercial properties, including homeowners associations, apartment communities, shopping malls, warehouses, stadiums and arenas, and more. Experience is worth more than anything in an industry like ours, and our staff has decades of it. We have specialized equipment for any job, regardless of size, saving you time and money. DMI has a reputable history. We have been in business since 1956. We serve the state of Florida from 6 locations. Let us bid on your next parking lot project. Visit us online at dmipavingandsealcoating.com.
Rimkus Consultants offer the professional expertise to help condominium and cooperative communities provide safe, compliant buildings for their tenants. We have more than 170 Florida licensed engineers and architects who are experienced with local regulations and can assist with Senate Bill 4D compliance. We can help with milestone structural inspections, capital expenditure evaluations, structural integrity reserve studies, and developer transition reports. Focusing on energy, resilience, maintainability, and sustainability, our experts can help with every phase of the building life cycle. For mitigation after a catastrophic event, building restoration, repair and remediation consulting, or Senate Bill 4D inspections, please visit rimkus.com.
Welcome back to Condo Craze and HOAs here on our YouTube channel. Karen Curtis, Eric Glazer, he's board certified in Community Association Law. And we're taking your calls and questions. A lot of people are already on the phone, but the number to call is Glazer8. What is it? 717-Glazer8, 717-452-9378. Also, you have your classes coming up.
Yes, we do,
Well,
Karen. You know
sort
what?
of.
I forgot to even talk about that.
Actually, you know what happens in October? The legislature comes back in October as well.
Yeah, exactly, right. So it's a good time to actually start the classes because the Condo 4.0 bill is going to be spoken about by Representative Vicki Lopez.
Okay.
That'll also be going on. I mean, let me tell you something. Condo law and HOA law has
Exploding.
come front and center for the last few years. But you know what? Let's talk about the classes. Just to remind you, you don't get on a board within 90 days of being elected or appointed. You are off the board. You can also take the course within 1 year before becoming a board member. So either way, you have to do it now. You have to take an educational course. Our schedule is finally out. Start us off, Karen.
Yes, so these are all L&O Condo and HOA Expo starting at 8:30. October 9th, Palm Beach Convention Center. That's always a popular one.
Beautiful, beautiful facilities. I mean, it's gorgeous there.
Okeechobee Boulevard,
Yeah.
east of 95.
October 15th, the Broward Convention Center.
October 24th, Tampa Bay Convention Center.
Let me stop there for a second.
Okay.
Because when I go to Tampa, you have to know, just have to see it. They are so appreciative that I come there. They know I'm coming down from down here, and they know, it's a big schlep to go to Tampa, and they're so appreciative, and it is such an honor to be with them. It really, truly
And
is.
you love seeing them person to person.
Absolutely. It's not that it's not an honor to be with everybody else. I'm just saying they understand how far I'm traveling just to be with them. I really appreciate it.
It's not like you're going to Panama City or anything. So,
I've done that before,
I know
too.
you have. I know
Yes.
you've been all over the state. Jacksonville, too, I think.
Yep.
Bradenton Convention Center, that's October 29th.
Yep, and we end the season November 13th in Orlando at the Orange County Convention Center.
Do you think we'll know who's president by then?
when is election day?
The
November 5th? No, figure by January 1st, maybe of 2026.
What a mess!
Right. You remember as a kid, you had election day,
Yeah.
and you knew who
The
won.
polls closed,
The
and they'd
polls
have like
closed.
within an hour.
Right, and
I voted in my first election for Reagan. I was at the University of Hawaii. He had already won before I voted at 11 a.m.
Wait. Florida has 19 million people. What are we, third now in population?
Yeah.
We know by 10 o'clock
Yeah.
who won. Why is election day going on and on and
I
on
think you
for
know
days?
the answer to that.
I think I do know the answer to that. It is ridiculous. By midnight on election day, period, we should know the answer. Who won?
Well,
And
no,
what-
we got to let the
any
overseas ballots
that
come in.
after that, that's your fault. Period. We got to know.
They got to give them 2 weeks.
No, we got to know as a nation on election day who won. End of story.
Sorry, I didn't mean to take you off.
No, that's all right.
So, but
that's
by the way-
it's important to come. Now it's very important to come and take the course.
Well, what's interesting is that in condos you can vote electronically.
Yes,
Do you
you
think
can.
that'll ever happen? For
No,
us?
I don't. No, I don't think so. I don't think so. It's going to happen. That's really leaves open a lot of possibility for fraud. And by the way, I'm not saying it doesn't leave it open for fraud in a condo either.
Right.
Because it's a weird thing.
Yeah, but
You
look
really
at
don't
her.
get
She
to
hasn't
see.
had anyone vote for her, so it doesn't really matter.
Harris? No, I hear you. You talk about the rights of the Democrats being taken away from them, but that's another story
Okay,
for another
so
day.
to
Right.
register, go to our website, www.condocrazeandhoas.com. So you teach so many different topics at the seminar, including the safety and inspection and reserve funding laws, the importance of the from time to time language.
Let me stop you for a second right there. This show has really awakened, I can tell you, it has awakened the Kaufman language problem.
Really
I'm
good.
telling you that we did that here,
Good.
okay? The legislature is going to be forced next year to somehow fix this, because the only real way, the best way to fix this is if we go back up to the Florida Supreme Court with another case, and the Florida Supreme Court says, okay, we were wrong in 2011. The state of Florida has the right to make condo laws that apply to everybody, okay? It's not a violation of their constitutional rights. That's going to be next to impossible, very hard. So the legislature is going to have a tough job of figuring out, okay, if the Supreme Court's not going to do it, how do we do this at the legislative level? And I think my partner Richard Sachs had a fantastic idea of not changing the condo law, but changing the corporate law, because everybody is
Sure.
a not-for-profit corporation.
Sure.
Changing one little sentence in there would potentially make all the new laws apply to all associations as they come due.
how many, we started the show with all of these condos in Miami, the ones that are 30 years and old, the people are selling.
Right.
Well, how many of those condos don't have the Kaufman language?
Oh, man, so you're telling them don't sell yet, huh?
Yeah.
Maybe there's a savior.
Yeah,
So what Karen
maybe
is
it doesn't
saying
apply
is,
to you. Hold on, because at 90%.
oh, what you're starting. Do you realize what you're starting? No joke.
Yes.
No joke. This is
But
a
it's
major,
true. Look at your documents.
Yes, you may not have to pay reserve funds, believe it or not. Everything I fought so hard for, right? Mandatory reserves. If your declaration does not have Kaufman language, and your declaration specifically allows you to waive reserves, it's got to be in there that the declaration allows the unit owners to waive reserves.
It doesn't say amended from time to time.
If it doesn't say that,
You
it's
are
a
good.
pretty good argument.
Well, not good, but.
That you want to go to court and say that doesn't apply to me.
And then you'll take it to the Supreme Court.
I want to defend the association. Seriously, I'm looking into the camera and saying it. I want to defend the association, and I want to have the Supreme Court look me in the eye and tell me after what happened in
Cohn versus Grant.
in the tragedy
Oh, yeah.
in Surfside, that the state legislature didn't have the right to do what they do and do what they did with the new laws and have it apply to everybody, so that we don't have other tragedies in Florida. I think it's going to be a pretty tough call for the Supreme Court to do that. So I'm waiting for a case. I hope a case comes. I really do. I'd love to defend an association on that. And let's get it up to the Supreme Court.
Can these boards call
And
you?
by the way, and it would get up there quickly.
Of course.
Because we could, if a case was filed right here, let's say on Flagler Street, if we're talking about Dade County, or on 6th Street in Broward County, right? Or in Palm Beach County, if one of those cases were filed, whatever the decision was in the circuit court level, at the triad court level, it's a decision of such public importance that I think it would skip the middle range level, right?
Okay.
The District Court of Appeal level.
Leapfrog.
Boom, we go right to the Supreme Court.
Because you argued this the last time, Cohn versus the Grant.
2011.
And they said no.
And they said, nope, these laws that the legislature make do not apply to associations that don't have Kaufman language.
It's a contract
Yeah,
situation.
because it alters their contract. It's an insane situation that Florida is in.
So if a board doesn't
gotta
know if
fix
their language is there or not, can they call you and you just look at their docs real
absolutely.
quick?
That's what it is, yeah, correct. Okay? All right, how about we take our first phone call today?
Sure, let's go to the callers. We have Sean.
Hey, Sean.
Looks like Sean from Hollywood.
Sean from Hollywood. You there, Sean? Okay, go to the next one.
Oh, he's there.
Oh, Sean, how are you?
Hi, how are you?
Okay.
My question was, with regards to the new law, does the board and its property manager and its board association attorney have a fiduciary responsibility to act in the best interest of members, including both handling membership dues and preserving and protecting property values of members?
Well, the statutes for both condos and HOAs say directors have a fiduciary duty to the owners, not the manager, not the association attorney. Directors owe a fiduciary duty to the unit owners, simply meaning that the directors have to act in the owner's best interests at all times. That's what that means. Okay.
Does the property manager have any type of duty to act in the best interest of the condo members?
The property manager basically acts at the direction of the board of directors. They have to act according to their contract. I hope that in your situation there is a contract, and managers cannot do anything that violates Florida Statute 718, 719, 720. You know, as much as they have to listen, they can't listen to the extent and break the law. Same thing for attorneys. My client can't tell me to break the law, and I can break the law. If you do that, you're getting disbarred. If a manager does that, you know, you're going to lose your license. It's the bottom line.
The association attorney, is there any duty to act in the best interest of the members?
The attorney acts at the direction of the board of directors. If the board of directors tells that attorney to do something legally, then that attorney can do something legally. If the board is, if the attorney is asked to do something illegally,
Then you got the crime fraud exception.
right, right. But no, you can't act illegally. That's
No.
the bottom line. There's no specific duty that the attorney owes to the unit owners.
Just the board.
He works, that attorney, yes, it works for the association, and the association hires or votes for these 5 people to tell the attorney to do what the attorney should do. And as long as the attorney is told to do something legally, then the attorney should act at the direction of the board.
But the attorney can advise them. I don't think that's a good idea.
Exactly. Now, can say is a good
Yeah.
idea. But if the attorney is uncomfortable doing it,
Yeah.
get out.
Yeah.
Say, I'm quitting. Goodbye. Okay?
Okay, thank you.
Thanks, Sean. Who else we got?
Let's go to Bruce. He's got a question about
Hey, Bruce.
balconies.
Balconies.
Balcony restoration.
Bruce, how are you?
Are things flying off your balcony?
Bruce, you got 5, 4, 3, 2, 1. No Bruce. Next.
All right. Bruce, if you are there, just call back.
Who else?
Let's go to Arlene.
Good morning, Arlene.
Hello?
Hey, Arlene, how are you? Good morning.
I'm well, sir, and thank you for all of your wonderful knowledge. I've been to all your Palm Beach County convention. I'm a CAM license holder, and
Nice.
Thank you so much. I
you're
appreciate it.
amazing.
Coming,
My question.
coming from a CAM, it really means a lot. Thank you so much.
My pleasure. If a condo owner is being is looking to be voted in as president of the board, or any member of the board, but specifically president, do they have to be an American citizen?
No, absolutely not. They have to be an owner of the condominium unit.
And they don't even have to live there.
Yep, they don't even have to. They can.
Be in France.
They absolutely, exactly.
They can be in jail.
They can go back to El Salvador, just cross the border again at the Rio Grande, and come right back home,
You did
and
not.
right there, and just be president. Right, no problem. Absolutely, you do not have to. You do not have to live at the condominium. You don't have to be a U.S. citizen. Absolutely not.
Now, can the wife be on the board if she's not on the deed?
Can the wife be on the board if she's not a deed? No, she cannot.
Okay, there you go.
Absolutely no. And then, you know what? I can't violate attorney-client privilege. Let's just say I had a situation recently in my office where one of the spouses thought they were on the deed and they were not.
Oh.
Yeah.
It happens more than you think.
It happens a lot more than you think. People want to run for the board and they're like, no, I'm on the deed. And I'm like, no, you're not. Yes, I am. No, you're not. And they think it's impossible.
Yeah.
And they find out that they're not on the deed. Happens a lot.
Yep.
Yeah.
I know about that.
Yeah.
So the only qualifying is you have to be on the deed and an owner. That's it.
So there's, if you look at the statute, what does the statute say? That you cannot have been convicted of a felony, right? And
there you go.
where your voting rights have not been restored for at least the past 5 years.
But you could be in misdemeanor and in jail for 300 days and still
Yes, correct. I don't want to get too technical, but I believe if that misdemeanor could have been a felony in Florida, that might prevent you from being on the board as well. But again, you can't be on the board if you were convicted of a felony and your rights haven't been restored for at least the past 5 years. Now, sometimes it's hard to know if that even, how do you know if this person's rights were restored for the last 5 years?
How do you find
it's
that out?
difficult. Well, one of the ways is show me that you have the right to vote.
Okay.
And if they say, I just voted in the election, what are you talking about? Well, then
some
it's
people
apparent
vote
that
and
they're
they don't have their rights restored.
So, or any right to vote at all.
Right.
You know? That's the answer to the question. Okay?
There's a great
you
episode
so
you
much.
did.
You got it.
I think it was last season on this. I'm going to paste it into the chat. It's about specifically that, the requirements for being on a board.
Oh, there you go. Okay. Let's take one more.
Right, next caller would be John.
Hey, John.
Hello.
Hey, John. How are you?
Pretty good. I've got a question. We did not follow up on having passing the budget until March of this year. And the president decided, since we didn't pass it to that time, he went and put a special assessment and got it passed that we pay the difference of the new fee retroactive back to January. Can they do that?
Well, there's no choice, right? There's kind of no choice. There's two ways to do it. So in other words, what's your name? John, right?
Mm-hmm.
So what John is saying is, okay, normally a board passes a budget in November, right? And that budget is for next year. So in other words, in November coming up in 2024, the board is going to pass a budget that will apply starting January 1st, 2025, okay? But in his condo, they screwed up. They didn't pass a budget until they were 3 months into the year, right? January, February, March. So now January, February, and March are short, right? Because this budget is going to be requiring a certain number of dollars to be paid each month based upon a 12-month schedule, but January, February, March didn't pay it. Or, you could amend the budget going forward. You can pass a budget only for the next 9 months. That's one way to do an amended budget, or a special assessment to make up for the shortfall. Probably the better way to do it, the more legal way to do it, I would think, is to amend the budget. So the arrearages, the amount of money that you were short for January, February, and March, would simply be now spread out over the next 9 months.
Okay.
Does that make sense to you, John?
Yes.
Yeah, that's how it should be done.
We've got,
not by special
because
assessment.
along with, I'm sorry, go ahead.
No, not by special assessment. It should be done by an amended budget, where now we have to figure out what the right payments are going to be for the 9 months, because there was a screw up for the first 3. Okay?
And they did the same thing with the election. So when it came up to in April, they had the election. They messed up the election 2 times in a row.
Oh, Lord.
So when they had it in April, they decided, well, we won't have an election. And the manager stepped in and said it in the minutes, and he says, you only have two options. Either continue with the board that's on there now, or else have another election. But he recommended we not have it because it's going to cost us money.
That is
allowed?
Completely irrelevant as to whether or not it's going to cost you more money. If you did it wrong, you need to do it right. End of story. It's kind of an unbelievable, ridiculous statement by your manager to say, no, it's too much money to do another election. Well, somebody screwed up the election. Is it the manager that screwed up the election?
I mean, what is the cost of
it? It was a management company, because we changed right during the election process. We changed, and it was all messed up.
Whatever it is, you have an obligation to the unit owners to do the election correctly. That's what you should do.
Unless nobody new is running, you could just roll the board over.
Correct. If there wasn't enough people running, it's a different story. Correct. Okay. We got to take our final break of the hour. Great phone calls today. We didn't even get a chance to take any questions from the chat box.
Oh, we will.
Maybe we can when we get back. Keep the calls coming, 717-452-9378, or drop us a question in the chat box. Be back right after this.
Is your condominium or HOA in need of accounting services? Look no further. Gerstle, Rosen & Goldenberg is one of South Florida's largest accounting and auditing firms, as recognized by the South Florida Business Journal, and is one of the few accounting firms uniquely specialized to provide accounting services to their growing condominium and homeowner association clientele throughout Florida. With primary offices in Aventura and Boca Raton, satellite offices in Naples and Orlando, and a professional staff of 65, Gerstle, Rosen & Goldenberg is prepared to meet the needs of any condominium or HOA in the state. The professionals at Gerstle, Rosen, and Goldenberg also have experience working with timeshares, cooperatives, hotel condominiums, mixed-use buildings, and ancillary operations like restaurants, spas, and country clubs. Put their 25 years experience in your corner. Gerstle, Rosen, and Goldenberg, 305-937-0116. That's 305-937-0116 or grgcpa.com.
All over the world, people have plumbing problems. These problems can be expensive and destructive to fix. Have you ever wondered if there was a way to take care of your plumbing problems without destruction and an outrageous price tag? Welcome to Pipelining Technologies, Inc., where we specialize in fixing your problems without demolition and minimum cutting by means of pipelining. Pipelining is the ability to take a pipe damaged by root intrusion or long-term deterioration and make it new. By means of inserting an epoxy-saturated liner into the pipe and allowing it to harden or cure, leaving behind a brand new pipe.
That sounds great. How can I get pipelining in my home, commercial building, or condominium?
Simply fill out our online contact form and a pipelining representative will get in touch with you in a timely fashion. Or call us directly at 561-853-5463.
So welcome back to Condo Craze and HOAs here on our YouTube channel. By the way, this is our second break, so we still have like a half a show to go, so we might go a little bit longer because we've been yapping. Sorry.
A lot to yap about today.
And Barry, your friend who helped get this legislation passed, was saying that there is there are several reasons why you would not want to restrict board members only to unit owners. And your documents have to say you have to be unit owner, by the way, he says.
So, yeah, I see it. The declaration might not require board members to be unit owners. You can be a board member if the declaration doesn't have that restriction. A lot of people don't even know, they can't believe that that's in there. That's right, okay? A lot of times you can be a board member in a community even if you don't have own a unit there. And it could be, I don't know why anybody would want to do it, but it could be that you want to get somebody from another community who's really, really bright, okay, who knows a lot about this stuff, and say, hey, would you mind serving on our board? It would really mean a lot to us.
You can make it a president.
Make them the president,
yeah.
Absolutely. And it's possible, is what I'm saying. Is it common? No, it's not.
It's kind of like the Speaker of the House. You can put anybody in there.
That's correct. That's right.
Yeah,
you don't necessarily have to be
right.
Elected for that position,
right.
I believe. So Barry's right. Sometimes you have a situation where you don't even have to be a unit owner, and you can be on the board. Who else we got? Let's see. Mary M. Wish you could address HOAs, 720 more. You give condos a lot of coverage, great information. Hang into next week's show.
Oh, HOAs.
That I can tell you. We're going to talk about that and why still to this day HOAs are being treated like the redheaded stepchild. Why is it that none of this that we spoke about today, all the new powers of the DBPR to investigate all these things, why is it that not one of these things that we spoke about today apply to HOAs? And some HOA owners have been writing me a lot saying, what the hell about us?
Yeah.
And
they're just waking up to this.
I'll answer it this way, and it's no coincidence. We found out during the collapse of Champlain Towers that in the entire legislature, think about it, only one member lived in a condominium. That means every single other member lives in an HOA.
Well, there's some homes that aren't in HOA.
Very rare, right?
Okay.
So maybe they don't want their own community to be regulated. Oh. Maybe they don't want to pay the $4. Maybe they're on their own boards and they don't want to be looked at. There's a lot to talk about next week.
Interesting.
And we will. Back to the phones.
Let's go to Joanne. She's got a question about HOAs.
Hey, Joanne, good morning.
Hello?
Yes, how are you?
Good morning.
What's up? How can we help?
Fine, thank you. Thank you so much. Can you hear me?
Yes, sure can.
My question is, we recently removed 2 members of our, it's an HOA, and we removed 2 members of our ACB, which was a 3-member board. There's only 1 member left. Can that single member perform the duties of the ACB, change the composition of the ACB by our declaration? The BOD actually appoints members of the ACB.
Okay, so that...
And our declaration says a majority vote of the members of the ACB is required, and it says members plural 3 times in the original declaration. So can 1 member act alone on that ACB?
Is it clear that the ACB, and again, when you say ACB, is that like a architectural review board?
Yes, it is.
Okay, so if it's clear that it's intended for more than 1 person to serve on it, then I would say no, that 1 person cannot make a decision. Absolutely not. If the docs require more than 1 person to be on that board, I would say wait, fill the positions, and then let the decisions fly. Until then, no.
Okay, the docs don't mention a number. It has, the declarant had last 3 people appointed to it, and we're going over to self-managed.
Yeah.
So the last composition was 3, but the declaration does say a majority vote and 3 times of the members, plural.
Yeah, so it's clear.
So I don't think you can have a majority vote of 1.
Right. It's clear that you can't have a majority vote of 1. It says members, plural. So I think you're right. I think, you know, you understood before the call that it's got to be more than 1, and I'm going with that. I agree with you.
Not since Thomas Jefferson dined alone were greater minds gathered.
Right. And where is that? Here.
Yeah.
Yes.
By the way,
thank you very much.
Thank you very much.
Is the DBPR decision binding or non-binding? Gerald wants to know.
Which decision?
The DBPR, because we're saying that now they have more teeth, and then they can go to law enforcement.
Well, if a unit owner doesn't like the decision of the DBPR, whatever, they can, you know, take it to court, I guess, if they have to. But yeah, if the DBPR is going after you and is going to issue fines, violations, you want to take that to court or file an administrative complaint against the DBPR. I think that's where you'd have to go. Then yes, you're not stuck. You can certainly appeal that decision. Okay. Anybody else we got, Robert?
Yep. Let's go to David in Delray.
David, how are you?
Good morning. Unit owners are responsible for repairing or putting in their enclosures on their patios. Now, if the board wants to fix an individual unit owners and been notified not to because it's in violation of the docs, can they then be held responsible?
If they are told not to do it and they do it, when you say can they be held responsible, they can be required to remove it. Absolutely, at their expense. In other words, if they did not get the approval of the board to screen in their balcony, or not just screen in, I should say, glass enclose in. You know how expensive it is to do that?
Yeah.
And all of a sudden they do it, and they didn't get approval, and it looked, certainly they're from the outside, they look different than everybody else in the community. Guess what they just did? They spent a lot of money for nothing.
But can they get it approved and then grandfathered in?
Yeah, if the board wants to start letting people do it, if the community wants to do it, if the docs are mended.
But it's not a good idea to do it.
No, there's thousands, millions of condominium units that have glass enclosures now. As a
but
matter
I need to
of
do
fact,
it without permission.
You shouldn't do it without permission, right? As a matter of fact, we'll tell you that for insurance purposes, insurance companies love to see that you have a building not just with screens, you have a building that has glass enclosed all the way to the end.
Hurricane.
Yeah, hurricane-resistant windows. So, yeah, but if the board doesn't want to go that way, then that person who just paid all that money, they have a problem. Okay? Who else we got, Rob? Just make sure you get permission first. Don't turn a little issue into a big one, believe me.
That's right, because it'll blow up.
All right, let's go to Sam. Sorry, hang on.
Sam.
Long-time caller, Sam, actually.
Come on,
Third
Sam.
Eric?
Yes, how are you, Sam?
Hey, all right. Based on your subject today on the DBPR, I have positive results from them that I'd like to share to your listeners.
There you go. The
And
DBPR would love to hear it.
This was something that's been going on. It happened last year, and this was regarding the election process at our annual meeting. And all of a sudden, during this meeting, they decided, okay, we'll just have electronic voting. No notification, caught everyone off guard, and you had to do your election within a period of 5 days. They did some type of research, whatever, but when you voted up to 5, the people that were, you couldn't vote for 1, you couldn't vote for 3. So I challenged that. It's been going on, and now this past week we got the consent order. And
Beautiful.
It was in my favor.
Good for you.
In regards to the laws that they broke.
Right.
And
it sounds like
and they
several.
got to pay $500. They got to pay $500. The
Right.
association.
Right.
And the gall of it is the president says it'll come out of a special assessment that we'll pay for.
Yeah.
That I do not like, and I will
that's
challenge that.
That's what gets people angry. I just made a complaint. The DBPR found in my favor. They had put a $500 fine on the building, and I have to pay part of it. It's like sounds insane, right? But that's the way it works.
Mhm.
That's the way it is. Now, the question is, did the board learn a lesson? Maybe they would have learned more of a lesson, I guess what you're saying, if they had to pay it individually. But look, if people who are running for the board have the potential of paying for these things individually, you're not going to get many people to run. If this was an honest mistake, you're not going to get people to run. If this was intentional, I can see sure they should pay for it. Yeah, I get it. But you won. There's a situation where they didn't say we don't have jurisdiction. So good.
And this nine-page consent order has to be posted for 30 days.
Yes,
in a
good
common
for you.
area.
Yes, that's what happens when a unit owner is right. Good for you. I'm glad you prevailed. Thanks.
And the person that did this, the secretary, he has to take a course, which he completed.
Oh, good.
So
good for you.
So it was a slap on the hand.
Yeah. Oh,
thank you very much for what you do.
Thank you so much.
I just wanted to share this with the listeners.
Thank you so much. I really appreciate that. Good story.
All right.
Yeah.
And that's Pinellas County I'm from.
Thank you very much. The other side of the state. Very, very good. I mean, yeah, when you have an election, let's say 7 people are running for 5 spots, right? So you have 7 people on the ballot. If you want to vote for 1, that's your business.
Right.
Vote for 1. You want to vote for 2, vote for 2. You can vote for any number up to 5.
Okay.
Period. So they're saying, no, you got to vote for 5. Totally illegal. Gentleman was right. Let's take our final break of the hour. Keep the calls coming in, 717-452-9378, or drop us a question on the chat box in YouTube. We'll be back right after this.
In South Florida, the transition from bright sunshine to heavy rain and hurricanes can take a toll on your property's exterior and structural integrity. Cracked stucco, spalled concrete, they're more than eyesores. They can signal deeper issues. Now, with new Florida laws involving structural integrity requirements, we want to help you meet your milestone inspections and maintain the durability and beauty of your building. Since 2004, PD has been the trusted expert in structural concrete restoration, painting, and waterproofing for condominiums and commercial properties. We address the core of the problem, restoring your concrete's strength and stability to give your property a fresh, attractive appearance for many years to come. Visit pdpaintinginc.com or call us today, 888-416-3204, or scan the QR code to save our contact information.
This message is for anyone who has taken on the important responsibility of becoming an officer or director in a homeowner or condominium association. It is also for the management companies who work closely with these caring people to make sure things are done the right way. Hello, I'm Gil Pomar, South Florida Regional President for Center State Bank, now the second largest bank based in Florida. Our bank, Center State Bank, has an amazing team of professionals who are exclusively dedicated to the homeowner and condo association market. Your job is not easy. There are repairs and new projects that need financing. There are legal and social issues that need to be understood. There are also technology and servicing issues that your residents want to be improved. Why not choose a bank that knows this business backward and forward? Why not have a local banker who will meet with you face to face whenever it is convenient for you or your board? Center State Bank.
And welcome back to Condo Craze and HOAs here on our YouTube channel. We're going to go an extra 10 minutes because, well, we talked too much.
Exactly.
And we're still taking your calls.
Do we have calls there, Robert?
Sure do.
You sure do. Who do we got?
We have Greg. I'm going to put Greg on. Seems like Daytona.
Greg in Daytona.
Hey. Yep, good afternoon. Just a quick question about quorums. So if the memberships voted to have 5 board of directors on the board and 5 were elected onto the board and 2 of them resigned, leaving 3, is the quorum now 2 or does the quorum still stay at 3?
The quorum stays at 3. I have a good blog about this. Okay, I have a good blog about this. If your docs require 5, it is still 3. So I wrote a blog a couple of years ago. I remember it's like, what is a quorum, and you just look it up. Okay, read it. I urge everybody to do that. We don't talk about that enough.
Your blog?
Your blog.
Oh, man.
You know, how many blogs have I written by now? Hundreds and hundreds and hundreds.
And it's all, you can like search it.
Correct. You go on our Condo Craze and HOA's website, click on blogs, and then on the right side it says search. Type in any topic you want, and it is an amazing research tool. It's really fantastic. I urge everybody to do that. Someone wrote in here about having an electric vehicle charging station. They heard, here we go. Brian writes in, I saw on a lawyer website that the board can install an electric charging station for cars in a guest spot without going through the material alteration project.
Oh.
Is that right? And like we've said many times on the show, our office drafted the statute. Okay, Paul Kim in my office actually drafted the statute. We had a unit owner come in who bought an electric car, thought he was doing the right thing,
but he
came back to the association and said, hey guys, where can I put my charging station? They said, you can take your car out of here. We're not allowing you. So we drafted a proposed bill, had the bill filed, and the bill passed the legislature like that. At the time, there was only one other state that even had law that addressed this, and it was Nevada. Florida passed it like immediately. It was amazing. So yes, here's what the law says. I have it right on the board in front of you. The Board of Administration of an association may make available, install, or operate an electric vehicle charging station or a natural gas fuel station upon the common elements or association property and establish the charges or the manner of payments for the unit owners, residents, or guests who use the charging station and natural gas for fuel station. Okay? So yes, they have the right to do it, and look where I'm pointing my pointer if you can see it. It does not constitute a material alteration or substantial addition to the common elements or association properties.
But then what do you do when they all start fighting over it?
They got to make reasonable rules about it, right? So, you know, that's the bottom line.
They come and plug their car and they plug it into
everybody gets an hour once a week, or whatever it may be, as long as the rules are reasonable. Any calls, Rob?
Did we answer Greg's question? I forget.
Yeah, I think so.
Okay. Let's go to Joe, sorry. from Pompano Beach.
Joe, good morning.
Good morning, Eric. Thank you. Long-time listener here.
Thank you.
I have a question about security cameras. I've known from your show, with all of your recommendations and everything, that security cameras are a material change, and they have to be approved by the unit owners.
In a condo.
I'm in a big giant community here, and the legal advice that they're spreading around here is that security cameras can now be put in if there's some kind of security issue without a proxy. So
Right.
is there a new law that addresses that I don't know
Again.
of, or are we still on?
You're talking about in a condo, right?
Yes, a
Yeah.
condo.
The way I understand the law in a condo still at this moment is security cameras are something that constitute a material alteration to the common elements, and it still requires a vote, notwithstanding the fact that it's obviously a security concern. If there's some new case that came out, in the arbitration division, of which I'm not aware, I would tell is the talk to the lawyer of the association. Do you know who it is?
Yes.
Fine. Ask that attorney to send you that arbitration case that allows for the installation of cameras without a vote.
I'm
What's the
noticing in
harm?
my condominium association, there's cameras on top of the street lights on the road.
Oh, really?
What is
What's
that?
it?
I don't.
No
I never
idea.
noticed that before.
I have good question. Maybe they're watching you.
I know. I'm like,
have
every
no-
street light has a camera on it.
Did they get a
I don't
vote?
even know.
Exactly.
I'm like, what is this?
Well, some
You have
people-
taught me, Eric, that always ask for the statute. Can I get another quick question in,
Really
please?
quick, because we're just about out of time.
Okay. So usually at every condo meeting here, the president makes a motion not to read the minutes of the previous meeting.
Right.
So when they do that, then there's never a vote to approve the minutes of the previous meeting.
Yeah.
Don't they need to approve the minutes?
Absolutely. There's a difference.
to verify any voting that was done in the previous meeting?
Absolutely. There can be a motion to approve the minutes without reading them. Absolutely. But the minutes should still be approved. I agree with you completely. Otherwise, you just got unapproved minutes
So
that
they
go
don't
on and
have
on
to
and
read
on
them,
and
but
on.
they can approve them.
Yeah, and there's some case law out there that says if they're not approved, I don't even think they're official records of the association, unless approved. So
That was exactly my thought.
right. So so I would remind them that they still have an obligation to approve the minutes, even though they want to waive the reading of them.
Maybe
That's
they put them up
common.
on the website, though.
They should put them up
Yeah.
after, but after they're
They
approved.
That letter has
They-
to go to the lawyer,
Okay.
who's also getting the cost station thing.
By the way,
But,
they're asking
there's so many really basic questions to ask you that, I mean, I could be here
could
all
go
day,
on
but
forever.
thanks for your help. I appreciate it.
You got it, Joe. Thank you for listening.
To clarify, a lot of people are asking about the charging station. Can you put it in your spot that you're
okay.
deeded to?
Okay, so
'Cause
that's
not
the
just-
question of
yeah,
the day.
yeah.
So that's the situation that we had. Remember, I told you they denied our client.
Right.
So the bill that we passed, right, says specifically,
To make reasonable.
that correct. Here's I don't know, it's on the screen. The legislature finds that everybody should be driving electrical cars, that it's wonderful for the community. They can't prohibit any unit owner, if you see where my mouse is, a declaration can't prohibit any unit owner from installing an electric vehicle charging station or a natural vehicle gas station within the boundary of the unit owner's limited common element or exclusively designated parking area.
So it doesn't have to be voted on.
It does not have to be voted upon.
Remember the
That's
guy
right.
with the extension cords coming out the window?
Right. Now, you can't do that. You can't do that. You can put in a real electric vehicle charging
There you go.
station. Now, what I'm not reading to everybody is all the hoops that you have to jump through
Oh, boy.
in order to do that. Just let me take some of the obvious and we'll go out with that. Obviously, got to pull a permit for it.
Yes.
Obviously, it's got to be done by a licensed and insured
Right.
electrician.
And
right?
grounded.
Right. Obviously, you got to pay for the whole thing.
Sure.
The association's not paying for it. Obviously, you're going to pay the bill that comes in for your electric every single month.
You're not going to hook it to like.
You're not going to hook it to their meter.
electric.
Right.
The community
The
electric.
association can require you to get an insurance policy naming the association as an additional insured.
Okay.
A friend of mine had great for one of our sponsors. Okay. A friend of mine, another attorney, said, "Hey, anybody know how they can get insurance?" The association asked my client to get insurance for the electrical vehicle charging station, naming the association as insured. Nobody knew where to go. I mean, he was asking 100 attorneys what to do. He posted it up on a chat board. You know who came through with the answer? Our sponsor, Greg.
Gerstel.
No, Greg.
Oh, Greg.
Greg Waltz.
Waltz.
Came through with the answer. He gave the answer, and hopefully I put it up there for everybody to see. So, Greg, way to go. Okay, I really appreciate it. Short Partners. There's a couple of more steps that they can put you through, but if you're willing to do it, let's say you know you're going to live at this association for a while. This is going to be your home for a while. Put it in. Put it in. Why not? Spend it the few $1,000s it's going to cost.
You put it in your HOA. Did you have to get approval?
No, they don't even care. Yeah. They don't. I live in an HOA that's wonderful. They let you, as long as you're keeping your house look good, they don't bother you. But yes, you can put that electric vehicle charging station in your designated space. That's what the law that we helped get passed. And it's interesting. Now, I bought the Cadillac car, for example. They give you the money to put in the station.
They do.
Yeah. So
when you buy the vehicle.
Yeah, it all depends. So
holy smokes.
But in a condo, it may be more money. I'm gonna say $2,500.
Okay. Well,
okay,
it's worth
that's what I'm gonna say. But some vehicle manufacturers will give you back the money.
Okay.
So
Good to
that
know.
might be something you want to check out. All right. Finally, we've said a lot today. If you need legal help off the air, give Glazer and Sachs a call, 954-983-1112 again. During the week, 954-983-1112. During the week, we would love to help you out. In the meantime, everybody have a wonderful, safe, healthy week. I forgot to talk about one thing, and I'll just go out on this note. Because of the mockery that what happened at the Olympics to the Last Supper, I'll just go out on that note.
God can't be mocked.
I will not watch not 1 second of it. I could not care less. In my life, I was lucky enough to actually stand in the room where the Last Supper occurred.
Oh, man.
Yeah, I was in the room. I mean, what an amazing feeling.
Oh, my gosh.
To mock, and I'm not Christian, but to mock Christianity like that, I'm appalled
They put
as a
drag
Jewish
queens
person.
there as
Appalled.
Yeah.
But absolutely appalled. You think wokeness has gone a little too far? What do you think? When you see that, you think wokeness have gone a little too far? I'll end on that note. I don't know how everybody feels, but that's how I feel. The Olympics will not see me for 1 second. There's already sponsors who are pulling out, by the way. Sponsors are
really?
pulling out, and good. On that note, ladies and gentlemen, sorry, sometimes you gotta, when something is burning you up
It's
inside,
your show.
we have a microphone to do it, and I'm gonna use it. On that note, have a wonderful, safe week, and we'll see you again next Sunday, 11 a.m. on Condo Craze and HOAs. Be well, everybody.
Thanks, Eric.